Bhubaneswar Kalita. Shri Bhubaneswar.
Thank you, sir. I rise to support the enforcement of security interest and recovery of debt laws and miscellaneous provisions Amendment Bill 2016. Sir, as has been explained, the main object of the bill is expeditious recovery of loans of banks and financial institutions. Sir, there are approximately 70,000 cases pending in debt recovery tribunals. And my first point is that these DRTs has to be strengthened. I'm informed that the number of DRTs has been increased. Another 6 DRTs are created. But the long pendencies in the DRT or the adjournments is creating a delay in the process of recovery. Then shortage of judges, that has been mentioned already by some other speakers. And to that, I had the opportunity to be a member of the joint committee headed by Bhupendra Yadav. So we have discussed these points in the committee in threadbare and come into some conclusions which are incorporated in the amended bill. Sir, there is the age of the judges of DRT and DRAT had been a problem because there was shortage of judges and there was they were not getting judges. So that increase of the age bar will help to get hopefully get some more judges for speedy trial and speedy recovery process. So the main objective besides the recovery is to facilitate investment leading to higher economic growth and development. So this is a broad idea. We have discussed quite a few points on that, and most of it has been resolved in the committee itself. But there are a few things which I want to mention here. This will be, I will not go to the long points. I will restrict myself to the short points. One is the asset, the property. In the bill, the immovable property like land and all this has not been resolved. And there was some issues on that. So I think that issue has to be addressed by the government while finalizing this bill, because the property has been defined in this bill as immovable property, movable property, and in immovable property, land being a state subject, there had been some issues. I think the government, while making rules, I think these issues will be looked into. One of the main one of the main issue that was the issue of intangible assets. So the intangible assets are like know-how, patent, copyright, trademark, license, franchise, which includes also the brand. There was issues relating to this intangible asset. Brand is an intangible asset. And we have come across cases, at least one case, where the brand was valued at, self-valued at 4,000 crore. But when the recovery process has started, now the value that has come for the same brand is totally negligible. Totally negligible. So while determining the intangible asset as collateral or as asset, I think the banks will have to be, because since it is self-valued, so bank has to be bank has to see some mechanism so that this area is covered or secured fully in the fullest. So we had an issue about the asset recovery, asset reconstruction, ARCs. So here in asset ARCs, the small loans and the corporate debts are equated as one. So the small loan is different. Small loans like the loans given to the students, which has been mentioned by Navneeta Krishnanji in detail. I will not go into that. And loans to the small industries or MSMEs. These are not very big amounts. These are not large amounts. These are small amounts. And when you equate this before the ARCs, they are equated, then we see some injustice into it. The issue of the student loan has already been mentioned. You see, in one of the ARC, the student loan of more than 800 crore has been given for recovery with concessions of 40% and 15 years. And as has already been mentioned, if that 15 years is given to the student to repay, I think he will very well be able to repay that loan. So I think government must rethink about it, review about it, about recovery of the student loans and also the recovery of the small industries. Sir, the small industry has there is no collateral asset for the small industries. Their collateral asset-free loans up to 1 crore are given to the small industry. But I think we have to review on that because there is a demand that this collateral asset-free loan should be increased to 5 crore. And the student free, I think these two areas, the area of the student loan and the area of the small loans to the small industries can be reviewed by the government. So this morning only, Honorable Finance Minister has mentioned about 4.70 lakh crore gross non-performing assets of the public sector banks. That is besides the NPAs of other financial institutions, and which is about 9.32%. Here, the cases, there are genuine cases, there are cases which has been detected, which has been in the public domain, that those NPAs are willful. So the government has to differentiate, as has been mentioned by some other members also, that willful defaulters should be treated under criminal law than the civil law. And when you talk about willful defaulters and the NPAs of the public sector banks, the public sector banks have, in many cases, more than one cases, we find there are vested interests. There are vested interests on the loanee, there are vested interests in the bank, there are vested interests in the allied field. So they altogether defeat the purpose of a loan for which it has been taken and which could have been very well go to some other sector and add it to the prosperity of this country. And while concluding, I will request Honorable Finance Minister to look into these two areas of student loan and the loan to the small industries, and also define and find some measures about the willful defaulters to bring them under criminal law. Thank you very much, sir.
Thank you very much.